Hello, and my name's Allison Munroe. I'll be chairing today's webinar, and I'm delighted to welcome you to this, our first and our launch webinar, and in what will be a series of webinars provided by Garden Court Chambers, looking at legal issues and surrounding issues arising out of the COVID crisis. And in the coming weeks, we hope to be looking at, amongst other things, other issues, including family law context and how within the family justice system, how COVID has impacted there, the adverse effect of COVID on refugees and those in immigration detention. And also we'll be looking at some medico-legal issues in terms of trying to understand better some of those issues that are involved. So lots to come in the coming week. I'm delighted in this first launch webinar to be bringing you a stellar panel that will be looking at public inquiries and inquests, accountability in the time of COVID. We are looking at a panel here that will be bringing their own unique and diverse perspectives in relation to those particular topics arising out of today's webinar. I should also say, before introducing our panel, a huge thank you to Abigail Holt, who's one of the senior practitioners in the civil liberty team in Garden Court, and very much the motivating force, one of the motivating forces, both behind this particular series, but also in terms of organising, which we are extremely grateful to. So thank you very much to Abby. Without further ado, I'll just list who our panel are before we go into our first speaker. We have Stephen Simblet QC, who's a member of the Civil Liberties team here at Garden Court. Adeyemi, who's a MBE and Managing Director and Founder of Global Health Jobs. Elkan Abrahamson, who's a very well-known solicitor and Director at Brady Jackson Canter Solicitors. And Elkan will be here with Hannah Brady, who's a member and spokesperson of the COVID-19 Bereaved Families for Justice UK. And they will be bringing their very particular and very prescient presentation about issues arising there. And finally, we have Professor Leslie Thomas, Queen's Counsel, again, a leading member of Chambers in the field of inquests and public inquiries. So without further ado, I will go into our first speaker. You should see, by the way, just by way of housekeeping, in the chat, there are some housekeeping matters which inform you how the webinar will progress. Any questions, please put them in the Q&A. I'll be monitoring them as we go along. Also, just to let you know, this webinar is being recorded and it will be on YouTube as well, so people can, anybody who missed the beginning, because I know we've had, even in the time I've spoken, we've had quite a few more participants joined. Don't worry, you won't miss anything, it's all on YouTube. So without further ado, I'll go into our first speaker on the panel, who is Stephen Simblet QC. Stephen is a leading light, and I don't say that lightly, it is true. He's a leading light in the field of inquests and public inquiries. Stephen is known for some of the most highest profile cases he's been involved with, Hillsborough, the child abuse inquiry. So he comes from a position of great knowledge, and Stephen, along with Elkan and Leslie, will all be providing a sort of legal basis and understanding of how public inquiries work, the particular difficulties and particular challenges about public inquiries. So Stephen also has produced some very swanky slides, which will be available to the participants after the webinar on request. So over to Stephen.
Thanks, Alison. Just while I line up my slides. I can do that. Share screen, so I shall share my screen. We practiced this only about 2 seconds ago, and I still managed to cock it up. So hope it goes better. Right, there we are. Is that right? Are we looking at the slide? that just says Garden Court?
We are,
No.
Stephen. We're
We
good to
are.
go.
Right, good. Okay, we will start then. Right. I've handed over remote control to Amy. It's a bit scary. It's a bit like sitting there while things happen in front. Is that all right? So it should be all right, shouldn't it? This is, I mean, I only did these slides because if we're having a COVID inquiry talk, I thought, what sort of a talk is that without somebody saying next slide, please? So here we are. I've done my slides, and I will start with the first one, public inquiries. That's me. And the first thing I wanted to point out was some of the sort of cynical reasons that, or the skepticism that people have over public inquiries, or certainly public inquiries as they exist in their current form. And I know Elkan is going to talk about something about this in his talk, because currently, whereas it used to be the case that public inquiries were subject to a 1921 Act, judicial inquiries, judges and parliament had a role in setting the terms of reference and so on. The government, or down the years, the governments have got concerned about the extent to which public inquiries actually do lead to beneficial change when they'd rather control the narrative. So although there was a 1921 Act, around the early 2000s, a number of things happened that made the government want to change things. The first of those was the Hutton inquiry, because as you will remember, David Kelly died in very mysterious circumstances. Normally, there would be an inquest into a death where somebody's found lying under a tree with an excised excised wrist wound, and such an inquest would have evidence on oath. But due to various reasons, the government decided to hold an inquiry where, in fact, Hutton didn't hear evidence on oath, and the witnesses were questioned by counsel to the inquiry rather than by the representatives of the people involved, such as, for instance, David Kelly's widow, and the government was able to control the information available to the inquiry. And of course, as you will remember, there was a lot of political and Secret Services concern over it. So the government was keen to control it. And in a sense, that sort of inquiry and the role that the government has in being able to limit its utility formed part of the template for the next thing that the government did, which was the inquiry to set into the death of the lawyer Pat Finucane, because in 2004, the Justice Peter Corey from Canada reported to the British and Irish governments about the circumstances in which Pat Finucane had been killed, and there were all sorts of well-founded allegations of Secret Services involvement and collusion with loyalist groups and all of those sorts of things. And the British government, while the judge, Peter Corey, recommended that there be a full public inquiry set up, and the British government at least wanted to pay lip service to that, it was rather more concerned about what in fact might be found out. So what it did was it accelerated through Parliament an inquiries bill, which became our current Inquiries Act 2005, and really did push this through Parliament. There was hardly any opportunity for any MPs or members of the House of Lords or anybody else to explore and consider in detail the changes. And in effect, the 1921 Act was replaced with a much more government of the day friendly method of holding these sorts of inquiries. I'll move on to the next slide, please, because and that in fact had a number of effects in the Finucane effect itself, because although they ultimately had an inquiry, the inquiry that was held was not adequate and did not comply with Article 2. I'm rushing through this slide because we're concerned with COVID rather than the Finnegan inquiry, but it's nevertheless an important starting point, as I've put in the last bullet point on this slide, that the current Inquiries Act may well meet, if operated in the way that is set out fully in the legislation, may well mean that there are certain aspects of the inquiry that would not comply with the requirements of an Article 2 investigation. So at an event where we're looking at how a COVID inquiry should operate, we need to be particularly mindful of that. And those who know anything about the Manchester Arena inquiry will know there's been a lot of discussion about that there, and also in Grenfell, and Leslie is going to tell us something about the practicalities of that later on. Now move to my next slide. Yeah, so here is the Inquiries Act. The first thing to note is it is set up by a minister. So the minister, i.e. if the inquiry were being set up by the government under the Inquiries Act as it currently stands now, somebody like Matthew Hancock would set up the inquiry, decide who the chairman should be, decide what the terms of reference should be after consulting with the chairman, but nevertheless retain the power at any time to amend the terms of reference. So the key message, and that's why I put it in bold on the bottom of the slide there, is that under the Inquiries Act, an inquiry that is set up will normally be under the control, effectively, of the minister to a very considerable degree. And it's not Parliament, if it's under the Inquiries Act, that sets up how this thing should proceed. The Act sets up various provisions in relation to membership, the chairman plus members, if thought useful, and there were particular provisions dealing with suitability, impartiality, and expertise. But essentially, it remains largely the minister's decision as to who should be on this inquiry. And one of the things that, from a practical point, that is going to be important in inquiries such as this is the presence of members and what who those people are and what sort of impartiality and expertise they can bring to this inquiry or an inquiry. And I'm taking this quickly because at the moment I'm setting out some of the problems there are under the Inquiries Act. So the Inquiries Act chairman sets the procedure. He or she has the power to take evidence on oath, but is not obliged to. There is an obligation to ensure that the public can access the proceedings. But again, in Grenfell and in the undercover police inquiry, there have been issues about how some of that operates in practice, and ironically, particularly in the time of COVID. And even alongside even alongside that power of public access, there is a procedure for keeping things out of the public domain, a restriction order procedure, which is actually very wide in ambit. There is a power to restrict material from the public consideration, which takes account of harm or damage, with a very broad definition of harm or damage, which includes not only national security and international relations, but also the economic interests of any part of the United Kingdom, or, again in quotes, disclosure of commercially sensitive information. So how is that going to play out in a COVID inquiry? Particularly since the Crown can apply to prevent information being revealed where there is a risk of damage to the economy. So these are all reasons to doubt the efficacy of an inquiry set up by a minister under the Inquiries Act, and all points that will be being considered by Elkan and Leslie as well. But so the starting point is the main statutory tool that we have for proceeding to hold a public inquiry is one that has a lot of difficulties and unfairnesses when it comes to getting justice for people whose lives, welfare and livelihoods have been affected by the government's handling of the COVID pandemic. How you participate in an inquiry is by being designated as a core participant. Leslie's going to tell us something about this, but there are certain statutory definitions of core participant. And not only is it people, not only is there this broad definition of significant interest in an important aspect of the matters to which the inquiry relates, which I would say ought to include a whole, is the vehicle for including a whole range of potential participants, not only bereaved people as that with that status, but those involved in frontline care, those involved in businesses subject to restrictions, people who've been put in difficulty running their businesses, such as care homes who had vast numbers of people discharged from hospital into their care homes, essentially importing COVID from hospital into those homes. So a whole range of people who ought to be able to fall within the core participant label within the Act. So probably that's not too restrictive. But when it comes to how, in fact, you then participate in the inquiry as a core participant, we then run into some other problems. Because you can be legally represented. The chair has a very considerable degree of control over how your representation is in fact delivered, including having a power to require particular core participants to share their representative or lawyer. But then, and this is perhaps the vanity of the advocates involved here. I mean, what is it that then the core participants and their legal representatives can do in terms of taking part? Well, one thing they can do is make opening and closing statements, subject, of course, to the chair limiting the time that she or he affords to them to do that. But when it comes to, say, the questioning of witnesses, the default position, as set out in Rule 10 of the rules, is that it is counsel to the inquiry, and the panel themselves, of course, who can question witnesses. And if you want to ask your own questions, the idea is that you inform counsel to the inquiry what it is you want asked, and or you make an application to question a witness and say why it is you want a particular question asked. And the trouble with this procedure, from the perspective of somebody like me or Allison or Leslie or whoever else with experience in representing bereaved families at inquests and so on, is it's not the way that the client would necessarily like the question asked. That is the way in which it is in fact put to a witness. So, for instance, it rarely turns out to be the case that counsel to the inquiry will be really taking a witness on and suggesting they're not telling the truth, or that they're not reliable in some other in the sort of way that our clients would expect us to be prepared to do, and also that we don't necessarily know whether in fact the question will be asked at all. And one of the pieces of reading that I would commend to you is the closing submissions that Leslie and Allison and Thalia Mirage made in their part of phase one of the Grenfell inquiry, whereas part of their closing submission, they had a list of all the questions they put forward that had not in fact been asked. And it's a long list. So, you know, that is a real, when it comes to what can the lawyer do for you in the public inquiry, it's important to note that under the Inquiries Act as it stands, there's pretty limited role for the advocate to ask the questions. I'm just nearly over my time. So yeah, it's worth pointing out there's a slide saying that there is a power in the minister to convert particular other inquiries and inquests and so on into inquiries under the Inquiries Act, and to bear in mind that when we talk about the Hillsborough inquests, they were inquests properly conducted as such, and were not an inquiry, and so the sorts of problems that we see under the Inquiries Act did not apply there. So, and that's it. That's my 15 minutes of fame, and I'll hand over to somebody else.
Thank you very much, Stephen, and thank you for using your 15 minutes of fame so well. It's really interesting and really useful analysis there of some of the difficulties and the differences between inquests and public inquiries, but some of the difficulties as lawyers with public inquiries. So thank you very much for that, Stephen. Our next speaker is Adeyemi, MBE. Ade, I'd said at the outset that I'd be fairly brief in my introductions to everyone so that I won't eat into your speaking time. Ade, despite his relative youth, he's definitely younger than me, there's quite a lot for me to get through in terms of being quick about your bio, so I'll be as quick as I can. But Ade, in terms of his background and what he does, Ade has previously served on the National Executive of the Fabian Society, Vice President of the Young Fabians. Indeed, writing for the Fabian Society, Ade won its 2017 Prize for Young Writers for his discussion paper on the ideas to improve BAME representation in the Labour Party. He has also been elected as chair of the Black, Asian and Minority Ethnic Staff Network for the NHS England and NHS Improvement. This was in March of last year. Is a member of the Davos World Economic Forum, the Global Shapers Community of Leaders, a fellow of the Royal Society of Arts, and senior associate member of the Royal Society of Medicine. He was nominated in 2014 as a rising star of the NHS by its leading publication, Health Service Journals. And just in his spare time, as you do, Ade has recently started studying for a doctor in philosophy in global health and social medicine at King's College London, having completed an executive MBA whilst working for UCLH Foundation Trust in London and being director for the African Global Health Leaders Fellowship at Chatham House. He also has a role on the main executive body of the NHS, NHS England and NHS Improvement, and is managing director of the Global Resources Platform. Finally, Ade did receive an MBE from the Queen in 2020 in the Birthdays Honours list for services to health, policy and leadership. So as you can see from that introduction, Ade will very much be giving us a presentation from a more medical health service and background, as well as looking at the impact, particularly on Black and minority communities. So without further ado, over to you, Ade.
Thank you, Allison, for a really warm introduction. And thank you, Leslie, as well, for the invitation, and everyone at Garden Court Chambers for scheduling this event. One of the things that I should probably put in the introduction as well is an update to my kind of job status, which complicates a little bit of what I can say today. But I am on secondment from NHS England to the Department of Health and Social Care. I'm now in the bilateral team of the International Directorate of DHSE. And actually in NHS England, I was also working on the commercial procurement of PPE. So it's really weird to, I saw on the participants list that they were sharing people from the Good Law projects that, you know, I'm supporting our Director Generals and making witness statements to the case there. And, you know, my history on the, I've seen it on both sides, but I'll start from my history of the situation, kind of from an NHS perspective of some of the challenges we're experiencing. And it's probably worth starting a kind of from a story of my experience as well as a user, and some of the challenges as a patient and user and person, also in the kind of system management side of it. Some of the things that I see and understand that then give light to the actual kind of inequalities and impacts that we see at the end of the day. So, for example, I have she's 2.5 now, she'll be 3 in July, daughter. And if and when, you know, she was a bit younger and we had any concerns, the mother and I would go onto NHS Direct website to look for information about a condition. I found out afterwards it was quite challenging to do so. So I went again in my spare time and I used this web scraper technology, which is basically what Google does to kind of find information from the web. And it's a bot that can scrape any information from a particular website. So I ran that program and I scraped every single JPEG and PNG image from the NHS website. 200 odd pictures. I don't have the slides to show you now, but you might have guessed where I'm going, which is that 97, 98% of them were of people, babies, adults, skin conditions with white appearing skin. So it was really challenging for me to have my daughter, and the mother's black, and understand actually how, you know, what is this meningitis? This is a rash. What is this? And that's just me as a patient. You know, you've got clinicians who read medical books, and again, the information is mostly for white male bodies. And so you can kind of see the problem I'm addressing, which is that when there's challenges in the actual design of a product, the inequalities and the health information that a patient or an end user can actually use can be quite challenging. And you might have heard similar stories from the, you know, use of test dummies, which are largely male, and how that impacts on end users, the design of phones, etc. And the National Health Service is no different. And that was one of the challenges we saw. And again, I'm being selective about what I say because I think some of this is public information, so my job won't be at too much risk. But, you know, we saw from the fit testing of PPE products, and the NHS did respond quite well to some of these earlier challenges. You know, there were risk assessments that were done. There were risk frameworks, risk reduction frameworks to encourage ward managers to understand actually, are we putting vulnerable nurses, vulnerable clinicians at frontline care? One of the things that's really challenging whenever I think about some of the systemic challenges we have with racial inequalities and challenges within the health service and what a public inquiry might produce, it's because there are these threads and these things which, as a patient or as a clinician, we kind of feel and see within the health service. And, you know, absolutely not a legal expert, but we look kind of informally at the likes of the other public inquiries that might have been done on social services, on the public, on policing. And, you know, I think for a large majority of ethnic minority staff, there's a feeling that, you know, some of these things that we feel within the NHS haven't really had any teeth and been exposed to, and COVID-19 has showed these inequalities that many people knew and felt existed, but they've really brought it to bear. If you were to look at the NHS England website, it would list the independent investigations that happen, and these are investigations that are largely patient specific. So when there's an episode of care which is in question, there's an independent investigation. So there is scrutiny within the National Health Service, and there's the health ombudsman and you know, other spaces kind of raise grievances. But when it comes to this systematic stuff, when it comes to the, you know, things that are quite knotty and hard to pin down because they're workforce, and it's not quite workforce from a kind of clinical safe staffing levels, it's something else a little bit more nebulous and hard to pin down than that. I think there's real interest and excitement, dare I say, in a public inquiry, because it feels like it's something that can actually, you know, give its teeth into and help highlight data and show from a systemic point of view some of the challenges that then result in the disproportionate impact of Black ethnic staff in the NHS. It's really challenging because when Stephen presented, you know, you think about the core participants, and who could be called to a witness in this case. We do have think tanks, we do have bodies that look at things in the round and they might be able to provide service. But ultimately, the practice that resulted in, or potentially resulted in, larger numbers of ethnic deaths from staff are from white ward managers who, again, I don't profess to have all the answers. It's just a really interesting question to then say, where would the witness or advocacy or line of inquiry come to kind of bring that to the bear? We see decision making and people that, again, are affected by the disproportionate impact of COVID aren't represented. So is it the lack of those people that then results in those inequalities in maybe challenging flawed system design outputs? It's a really interesting question to ask. One of the other things, though, I would like to highlight is the impact perhaps on the kind of health and well-being and the workload of people like me. So as chair of the BAME staff network in NHS England NHS Improvement, not only did I have a commercial kind of expertise I was trying to do with the PPE procurement and distribution, but you're also trying to do the advocacy piece. And there are many other clinicians like me who have roles as ethnic minority staff in the NHS, but also advocacy roles on top of that. And there isn't any protected time for that, largely, although we see other public sector organisations like the BBC have protected time for their BAME networks. We see that in the policing, we see that also in the army. But in the NHS, there are many BAME, so each trust as well has a BAME staff network, and they're called upon largely on volunteer free time to do the advocacy work that's affecting, or that's trying to affect, the situations of inequalities that they themselves face. You can see kind of the paradox there. And I wonder, again, will an inquiry like this call upon the efforts of a large group that haven't always been valued and have struggled to coordinate because they don't have access to the capital and resources to affect their situation? And so how do we do that in sustainable, ethical and fair ways? How do we galvanize, and how do we also give them hope? As Allison said in the introduction, I was elected into my position, which I'm no longer in for other reasons, but I was elected in March of last year, and you might remember the height of the kind of social conversation that was happening at that time. And there's a weathering effect amongst lots of colleagues, that there's been suggestions of this in the last significant inquiry in the NHS, the mid-staffs. There was a very pointed point about the issue of ethnic minority staff not feeling as comfortable calling out issues of discrimination. And without any teeth or without any promise about speaking up and what that could do and feeling protected, I do wonder as well what we will hear from ethnic minority staff, and also what avenues they can use to share evidence and to distribute that, given again the facts that they're in situations that they're trying to change. Just looking at my notes, the other thing that I think was interesting to share is the Race Disparity Unit and the work from arms of government in this space. So Public Health England did a report which called out some of the racist undertones in the situation of COVID-19. The race that's been picked up by the Equalities Minister and the Race Disparity Unit. I think amongst some of the medical community, there is hope that this evidence will come to light, and if and when a public inquiry is needed, then the racial impact of the disproportionate impacts of COVID-19 will be called out and will be given space to be investigated, because as I said, it's made its way through the Public Health England report, something that the Race Disparity Unit observes and works to, and also at the kind of higher echelons of government here, the Chief Medical Officer is engaging quite well with BAME networks, Sir Simon Stevens, many other NHS England, NHS Improvement system leaders engage well with BAME advocates, etc. So there is support, there is a galvanization kind of current happening. So if and when it's given the space within the public inquiry, you do hope that the terms of the inquiry will allow space for that to happen. I think I'm under the 15 minutes, but I'll stop there. There's not much else to say, but yeah, just really interesting to see this discussion, and look forward to any questions that I may be able to answer as well. Over.
Thank you so much, Ade. Some really important and very urgent talking points that you're raising there in terms of that race disparity. And we're talking about NHS, an organisation that in many respects, was founded on, the work of Black and brown people that came to the UK, in the 60s, late 50s and 60s, and really are, part of the backbone of the NHS. So this is a particularly urgent and prescient matter. So thank you so much for that presentation. Our next speaker, well, actually it's speakers. I'm delighted to have with us Elkan Abrahamson. Elkan is somebody that I first met. Elkan, it seems like it wasn't that long ago, but actually we're talking about 6-7 years now before we started Hillsborough. Elkan is the director of Brady, Jackson, Canter solicitors, and he is very rightly and very properly celebrated and known for his commitment to justice and representing individuals who are seeking justice and fighting for justice. It's been sort of epitomised perhaps with the work that Elkan did, representing a number of the families, bereaved families in the Hillsborough Inquests. But it's beyond that, Elkan also is somebody who is still now in the most recent area, justice for COVID-19 families, is again at the forefront of that. He has also obviously been involved in a number of very important inquests. Hillsborough, I've mentioned, Birmingham pub bombing inquest, and currently represents a number of families in the Manchester Arena public inquiry. So his breadth of knowledge on this area is invaluable, and we are extremely grateful for him coming today with Elkan, and they will be presenting this together. I'm also delighted to welcome Hannah Brady. Hannah is a member of and spokesperson for the COVID-19 Bereaved Families for Justice. Hannah, very sadly, last year lost her father, who was only 55 at the time, to COVID-19. He was a key worker. Hannah also lost her grandmother, her father's mum, to COVID-19 in a care home. She was in a care home in July of last year. Hannah's father had no underlying health conditions. After COVID, patients were discharged from hospital and cared for staff who often in the care homes often did not have sufficient PPE, had to make or buy their own PPE. So very sadly and regrettably, Hannah has first-hand direct experience of this pandemic and how it impacts upon people's lives. As I said, Hannah is a member and spokesperson of the COVID-19 Bereaved Family for Justice UK. And since June of 2020, and is one of the claimants in the proposed application for judicial review against the government's reluctance to actually even consider and commence a public inquiry into their handling of the pandemic. So I'm, as I said, delighted to have both Elkan and Hannah. I'll hand over to the two of them now for their presentation. Thank you.
Thank you, Alison. Just before we start and commenting on Adey's talk, one of the issues that has faced some members of the COVID-19 Bereaved Families for Justice is the discriminatory treatment of Black people suffering from COVID. And one example is when they rang 111 with symptoms of COVID, the algorithm, which by the way has not been disclosed for commercial reasons to the public, but the algorithm led the people at 111 to ask the question, are his or her lips turning blue? And that question is completely inappropriate for Black patients, and in many cases led to delay in treatment and may even have led to deaths. So that's just one example of something that I think an inquiry should be looking at. So can I start by introducing Hannah? Allison has already given a little bit of the background, but Hannah, if I can ask you, first of all, whether you'd like to amplify on that and explain what brought you to joining the COVID group.
Of course, yeah. Thanks, Elkan, and thanks everybody for inviting me. So my dad was called Sean Brady, and he was a key worker in a food factory, and he caught COVID, we think, before the 23rd of March 2020 lockdown, and spent 42 nights in intensive care on a ventilator in a coma until he passed away on the 16th of May 2020. And at the time that he was dying, his mother also contracted COVID in her care home after COVID positive patients were sort of shipped out of hospitals and shipped into care homes, about 75% of whom hadn't had a COVID test. So she passed away in July, with staff telling us that they were making their own PPE, that they were scared to go into work, but they knew that they had to because nobody else would care for these people. So pretty soon after Dad died and we managed to bury him, I came across COVID-19 Bereaved Families for Justice via Facebook. So it's a closed Facebook group, which means that not only is it a secure place for people to grieve, where they won't be subjected to things like online abuse, which we get quite a lot as COVID bereaved families, but it became a platform for us to organise contacting people like Elkan and starting to write to the government requesting that a COVID inquiry be commenced immediately with a rapid review phase, similar to the Hillsborough disaster. So we envisaged it would take about 12 weeks to have a brief overview of what went completely wrong in the government's handling of the pandemic in the first wave from sort of March to June to prepare for the coming winter. So some of our critics were saying things like there won't be a second wave in winter, when in reality we lost about 100,000 people in this country to COVID in the second wave. The government refused to acknowledge us, then they refused to meet with us. They're now saying they're too busy to even announce a public inquiry or, the form that it would take, which is really regrettable. A lot of other political parties are really keen to speak to us. We have the support of Labour, the Lib Dems, and it's incredibly frustrating that it's going to take bereaved people who have put their grief on hold to try and bring this government to a public inquiry and trying to get the answers that we all deserve.
Thank you, Hannah. If I can lead on from there and explain, when we were approached by the group, it's about a year ago now, and the first thing we did was approach the government and say why we thought an inquiry should be set up, and also why we thought it should be immediate, because there are probably two legal issues. One is whether only a statutory inquiry would satisfy Article 2, or whether there are other avenues. And that presupposes that Article 2 applies. The government doesn't concede that yet. And the second issue is the timing of the inquiry. Now, last summer, we felt there was a reasonable argument that the inquiry, or at least parts of an inquiry, should have taken place immediately. And the reason we were arguing that is specifically because of the timing of the second lockdown. We felt that there was an argument that an earlier lockdown would have saved lives. So we asked the government to agree to establishing an immediate inquiry just to look into that issue, really. Government said no. We said, well, if we apply for judicial review and lose, will you make the bereaved families pay the costs? Government said, yes, we will. We said, how much of those costs are going to be? And the government said, we won't tell you. And we know from more recent cases, in particular the Good Law Project case about PPE contracts, that the government was asking for £200,000 costs for a failed application for judicial review. Now, if you're talking about bereaved families who are already mourning, the last thing they want to do is expose themselves to that sort of risk. So the cost system was in effect used by the government to frustrate the families' desire to have these issues placed before the court. Since then, the families have been fundraising, and we're now in a position where we're at least in a position to start proceedings, but we now face the problem of timing. And the question now is, if, for instance, we went before a judge today and asked for an inquiry to start immediately, what would the judge say about that? Now, as it happens, in a very recent case from the Doctors Association UK, took, the single judge, when asked to give permission for judicial review, refused. And one of the things he said was, it's not for us to tell the government when to start an inquiry. I'm not sure that was properly reasoned by the single judge, and that application will be renewed, but that's something, it's another hill that the families will have to climb, put it that way. Given Stephen's comments on the restrictions of a statutory inquiry, I think I'd say our position is that it's the least worst option. What other format of inquiry is there into government conduct? And there's an analysis of all the various options carried out by the Institute of Government in a document, How Public Inquiries Can Lead to Change, from December 17, which I'd refer people to if they're interested. But basically, inquests and inquiries are currently the only forums where there is the power to insist that witnesses attend to give evidence, and the power to insist that they do it on oath, and the power to insist that they produce documents. And also probably the only forum which creates a criminal offence of destroying documents once an inquiry has been started, once the Secretary of State has actually set up an inquiry, which is quite an interesting power. I don't know if it's ever been used, but potentially quite interesting in this context. As to why a select committee inquiry is not good enough, and the government has said to us there have been, I think it's 50 select committee inquiries so far into COVID. Again, there's a very recent Privileges Committee report on select committees came out on the 2nd of May. And basically they make the point that although there is in theory a duty to attend to give evidence to select committees, in practice there's nothing they can do if people don't turn up. And you may remember Dominic Cummings, who just absolutely refused to attend. And the most they can do is admonish you, and frankly, who cares about that? So again, I come back to an inquiry being the least worst option. One other point I'd raise in that respect, and if I can, I'd just like to read you from the evidence given by someone called Chief Inspector Dale Sexton. He was the force duty officer of the Greater Manchester Police when the Manchester Arena explosion took place. Now, after the Manchester Arena explosion, there were a couple of non-statutory inquiries. One was the Kerslake inquiry. And Chief Inspector Sexton gave evidence of the Kerslake inquiry. What happened on the night was he declared something called Operation Plato, which is a declaration made by emergency forces in cases of a marauding terrorist attack. In other words, someone running around with firearms. And the idea of that declaration is to protect people and create a hot zone into which people, especially emergency services, can't go. So when you declare Operation Plato, you automatically tell the emergency services because they need protecting as well. He declared Operation Plato to his own police force, but didn't actually tell any of the other emergency services. Now, that's obviously an issue, but without going into that issue, the issue for me at the moment is, in the Kerslake inquiry, he didn't actually tell Kerslake this, and in fact, he implied that the other emergency services knew about it. So last week, he was asked in front of the statutory inquiry that's now taking place, why he didn't tell Kerslake, and he said this: I think the fact that even at that point in Kerslake, I didn't want for that decision almost to be known. I don't know why, but it was certainly something which wasn't mentioned to Kerslake. I don't know why I didn't mention it, but I certainly wouldn't have wanted to, as I had seen it. For me, I'd almost got away with it from the night, as I'd achieved to keep people at the scene providing medical treatment. Then after that, I suppose knowing it was such a significant deviation, I really didn't want to draw light to it. So in other words, this is a senior inspector in Greater Manchester Police basically saying, well, I thought I would get away with it with Kerslake because it wasn't a statutory inquiry. But now I'm here in front of a statutory inquiry, I'm going to have to tell the truth. And that, for me, indicates the great advantage, I think, of a statutory inquiry. If run properly, it can elicit the truth. So where are we up to on behalf of the group? I'd look at public campaigns like this as a three-legged stool. You try and get three things on your side. You want to get the public on your side, you want to get Parliament on your side, and you want to get judges on your side. We have problems at the moment with all three of those legs. As far as the public is concerned, they're not very interested at the moment in looking backwards to see what went wrong. They're far more interested in getting their holidays in Ibiza or Malta or wherever it is they're allowed to go. So there's a psychological problem at the moment with getting an inquiry off the ground. As far as politicians are concerned, as Hannah has said, we've made great progress with all political groups except the Tories. But anyone looking at the election results from this week, we'll see that the Tories are in a pretty unassailable position at the moment. So however much political pressure you get from the other parties and the other devolved countries, I think there's a real problem with persuading the Tories, A, to have an inquiry at all, and B, to have a statutory inquiry. And then we have the legal problem, which I've mentioned already. The current position, as far as the group is concerned, is that we have raised enough money to start proceedings, but probably not to finish proceedings if we have to pay a couple of £100,000 cost. So what we will be doing is starting proceedings later this year, probably when the government restrictions are fully lifted. So at the moment, we're looking at late June. If the stat inquiry isn't declared by then, we'll be asking for what's called a cost capping order, which is an order whereby a judge can say to the government, look, even if you win, you can't get more than X pounds costs. And frankly, if we're refused that, I don't think the group will be in a position to take the case any further. But I would hope that the court would at least put a cost capping order in place. Can I also, in the last few minutes we've got, mention that there's a group of Liverpool University students, some of whom I think are listening this evening, who are looking into what all the other European Convention countries are doing with regards to inquiries, because different countries are doing different things. I think Germany and Italy are conducting criminal inquiries already. So when the court at some point says, well, what's everyone else doing about their Article 2 duties, we need to have a picture of what every other member state is doing. And it will be interesting to see what emerges from that. I suspect at the moment, most European Convention countries are not doing a lot, and it's taking the same view that Johnson's taking here, which is it's too early to look into things. Having said that, I think those are all the points I wanted to make, and I think I've managed to squeeze it into 15 minutes. So thank you very much.
Elkan, Hannah, thank you so much. That was both informative, but also really in terms of looking at the practicalities and looking at how one gets a campaign off the ground. And it's very interesting what you said, Elkan, about getting public support and where people's heads are at the moment. It is about looking at, being insular, looking at themselves, when can I go into the pub as opposed to sit out the pub? When can I get on a plane? And that's going to be as much as a challenge as trying to convince this government to move forward. So those are really, really important points that were raised. So thank you so much, both of you, for coming today. And there are some very interesting questions that are coming up in the Q&A that we can, hopefully all the panel can address. But before we get to that, our final speaker is Professor Leslie Thomas QC. Leslie is a member of Chambers here at Garden Court, and I don't know, he probably won't remember this, but I came to pupillage of thinking I'd only be a criminal defence barrister, and it was going to court with a number of other people that opened my eyes to different areas of law. And one of those people I went to court with was this young barrister who took me to a coroner's inquest, and I thought, well, this is an area of law that's really, really different and really interesting, and it piqued an interest that developed. So thank you, Leslie, for all those years ago. Leslie has been responsible for some of the most important inquests dealing with, police and state brutality and deaths in custody, deaths in prison, shooting inquests, some of the highest profile matters. Leslie has been at the forefront and is at the forefront, and it's not, again, an underestimation when I describe him as, perhaps the premier and leading inquest lawyer in the country. Leslie has recently also been made professor at Gresham College, which is, I think, London's oldest higher education institution. And as strange as it may seem in 2020, but it's true, Leslie was the first Black professor at Gresham College. So Progress, it's a long time coming, but again, Leslie's at the forefront of that. Leslie's also presently involved with the Grenfell public inquiry, as Stephen mentioned. And Leslie, you may well have seen Leslie on the quoted on the television, because he has certainly been trying to push the boundaries in terms of what we can do on the Grenfell inquiries. And now I think Leslie's going to perhaps bring together some of the strands we've heard from other speakers, but also address some of the specific difficulties that we have and we find in public inquiries and how perhaps we can overcome those. So over to you, Leslie.
Oh, thank you, Alison, for that introduction. And thank you to the rest of the panel for your very informative discussions on this extremely important subject. I'm going to start with a quote, and it's a quote by Martin Fletcher, which was in the New Statesman on the 22nd of February of this year. And Martin says this: "The UK has less than 1% of the world's population, but has suffered nearly 5% of its COVID-19 deaths. For all its wealth and scientific prowess, it's lost 120,000, that was back then, it's nearly 130 today, thousand of its citizens. That is enough to fill Wembley or Twickenham 1.5 times, and is nearly double the number of British civilians killed in all 6 years of World War II combined. The pandemic has cost the Exchequer £280 billion, more than 4 times the annual defence budget, and has taken a terrible toll on jobs, businesses, and our children's education. There will be inevitably more pandemics, and it is in everyone's interest that we learn from this one." As I say, that was Martin Fletcher on the 22nd of February. So it goes beyond saying that the case for a public inquiry is a strong one. So what are the issues that those of us who are calling and the voices get louder and louder, what are the issues that we face? Well, the first issue I want to address is the composition of any such future COVID-19 inquiry. Now, as many of you will know, some inquiries are conducted by a chairman usually, because it's normally a man, not exclusively, alone, while others are conducted with a chair and other panel members who are known as wing members. Now, there can be very good reasons for using wing members, as one Public Administration Select Committee said in 2005, quote, "We agree with and endorse the view that the use of wing members brings expertise, reassurance, support and protection to inquiry chairs. We particularly recommend the use of panels in politically sensitive cases, such as non-statutory means of enhancing the perception of fairness and impartiality in the inquiry process. We also recommend that where judges are seen as the most appropriate chair, they should usually be appointed as part of a panel or be assisted by expert assessors or wing members." End of quote. You see, the use of wing members can often bring important expertise that a chairman does not have. And this is particularly significant where issues of race and social inequality are involved, since chairmen are usually drawn from the senior judiciary and consequently tend to be white and wealthy. So it's essential to have wing members from other backgrounds. For example, in the Stephen Lawrence inquiry, which was investigated highly contentious issues of institutional racism in the Metropolitan Police, Sir William Macpherson, the chairman, was advised by Tom Cook, a retired Deputy Chief Constable, and Dr. John Sentamu, the Bishop of Stepney, and Dr. Richard Stone, the chair of the Jewish Council for Racial Equality. the use of wing members has been a key issue in the Grenfell inquiry. Again, it's chaired by a retired judge, Sir Martin Moore-Bick. Controversially, Sir Martin heard the first phase of evidence on his own. And in 2018, there was a judicial review challenge to the failure to appoint additional members. That's the case of Crown against Daniels against May. That failed, but interestingly, shortly after that judicial review challenge was brought, the Prime Minister, in her wisdom, decided to appoint wing members. 2 wing members have since been appointed, an architect and health and safety expert, and a chairman of a housing association supporting Black and minority ethnic communities. I think it will be inevitable that a similar arrangement would need to be made for any COVID-19 public inquiry. We would need, would we not, at least one panel member with expertise in medicine and public health. We'd also need members with expertise in race, disability, and social inequality, since COVID-19 and the government's lackluster response to it have impacted poor people, disabled people, and people of colour disproportionately. Let me look at the second issue. And that is in terms of the references, the terms of references for the inquiry. It's vital, in my opinion, that campaigners campaign heavily on the terms of reference now, at a very early stage, since the terms of reference are set by ministers. They, forgive me for being cynical, but they are inevitably going to reflect political considerations and are going to seek to minimize criticism of government. So it's important that campaigners fight in the political arena and in the media to get the terms of reference they want. And it's interesting that that debate has already started. I mean to say, there was a recent article that I came across, which was set in some terms of references, and it set the following terms. Why was the government, or was the government, slow to order a lockdown? Once or more than once? What advice did ministers receive from their scientific advisory group for emergencies? SAGE. Are SAGE and Public Health England fit for purpose? Interesting that you see very early on in the public arena, in the media, that we are beginning to see the potential terms. And if you think about the article I started with, why have so many people in the UK died compared with the rest of the world, given the fact that we are a small, windy island? Let me turn to the third issue. And the third issue is going to be really controversial. Core participant status. I see real problems with this third issue, and this may well reflect the government's reluctance to call a public inquiry. Why do I say that, and what do I mean? Well, you see, the inquiries rules give the chairman discretion as to whether to designate a person as a core participant. Now, in a COVID-19 inquiry, this is likely to raise new challenges that no previous inquiry has ever faced. Potentially, anyone who has lost a family member to COVID might wish to be a core participant. So, So might anyone who's been hospitalized with COVID. Somebody suffering from long COVID. Somebody who's worked in frontline NHS care during the pandemic. So might every NHS trust and care home in the country. You see, when you begin to add this up, there might be hundreds of thousands of people wishing to be core participants. No previous inquiry has investigated a disaster on this scale affecting so many people. Even very large inquiries, such as the infected blood inquiry and Grenfell, have not been on this massive scale. Clearly, in reality, the chair is likely to exercise discretion and limit the number of core participants. People who are not core participants are also able to participate in inquiries. So this would not mean shutting them out altogether, but this option might raise a legal difficulty. What is that? It is this. It is arguable that at least some of the deaths from COVID-19 engage Article 2 of the European Convention on Human Rights. Deaths from natural disasters can engage Article 2 in some circumstances. We know from some Strasbourg case law on Yieldies, Broudie against Russia, to give two examples. On the basis of those cases, the Grenfell fire tragedy has been accepted to engage Article 2. So it's entirely possible that some or all of the COVID-19 deaths will be held to have engaged Article 2, particularly those which happened in the NHS or in care homes. Indeed, the argument is especially strong in care home residents, some of whom were detained there and were not free to leave, meaning the state bears legal responsibility for their deaths. You see, if the COVID-19 inquiry becomes an Article 2 inquiry, this imposes certain legal obligations on the inquiry. The Strasbourg case law has consistently held that in an Article 2 investigation, the next of kin of the deceased have a right to be involved to the extent necessary for the protection of their interests. In some circumstances, survivors of a disaster can also come within Article 2. It would be arguably difficult in this context to deny court participant status to bereaved families of COVID-19 victims or to survivors who came close to death. Yet, giving core participant status to every bereaved family and survivor who wanted it, given the sheer numbers involved, would be likely, if I were to put myself into the government's shoes, to become expensive and perhaps, they would argue, unworkable. This is a problem that the inquiry system has not faced before. Similar issue in respect of legal representation. Inquiries have the power under Section 40 of the Inquiries Act 2005 to fund legal representation for those participating in the inquiry. In a large and complex inquiry, legal representation for core participants is essential. We've seen this in Grenfell. But again, in an inquiry where there are potentially hundreds of thousands of core participants, this could become a massive and expensive endeavour. In short, a public inquiry, which there will be, is going to raise unprecedented challenges. This is a disaster that has affected everyone in the UK in some way or another. Huge numbers of people have died. Many have come close to death. Many are still suffering or have lost loved ones. Marginalized groups such as the poor, disabled, people of color have suffered disproportionately. Millions of people have a legitimate stake in the findings of the inquiry. Whoever the inquiry chair is will face an extremely difficult job of balancing the participation of the rights of the people affected with the need to conduct a workable and a manageable inquiry. But it's essential we do not allow this to become an excuse for whitewashing or covering up the truth, or for denying people a seat at the table. The practical difficulties are real, but we must be alive to the likelihood that politicians will try to deploy those difficulties cynically to protect their own political interests. You see, an inquiry is an inherently political process, although it's set up to look much like legal proceedings. Its origins and its effects are fundamentally political rather than legal. In the first instance, we need to fight in the political arena for the right to a meaningful inquiry that exposes the truth rather than covering it up. Thank you.
Thank you so much, Leslie. That was fantastic. We have now got some time for a Q&A session. We were aiming to, we advertised that we'd end at 6:30. There are quite a lot of questions. I know some of the panel can stay around a little after 6:30. And also I can see that Stephen, thank you so much, Stephen, has been answering questions and typing the answers to questions. And he's done about 4, which is nearly half of them. So thank you. But the live ones, we'll do some live. Perhaps if I can do it slightly out of order, because I know, Ade, you need to leave kind of 6:30 on the dot. And there's a question directed for you. So perhaps if I ask you this one first. It's from Sarah House. And Sarah says this: I live in Leicester, which is a very multicultural city. A study of NHS workers' willingness to take vaccines found that this varied significantly by different cultural ethnic groups. My question is, how do you see the inquiry will be able to unpack and not lose the attribution to systemic discrimination issues versus difference in living environments such as high density housing, multi-generational housing, cultural beliefs, etc., which may all have some impact on the levels of illness and deaths, etc. Big question, not a lot of time.
I'll do my best. I think what the colleague there was referring to is the social determinants of health, which are the non-medical factors that affect our health. So where we live, our knowledge about nutrition, etc. And that did play a big role. And we see other medical and non-medical factors having played a role. And I think the research is ongoing to determine significant contributors to COVID-19 or not, being, weight is one of them, gender is one of them, etc. I think from what we've heard from other speakers, including Leslie's last presentation, given the inherent political control for the direction of travel for this potential inquiry, it's, I think any wishes to see the systemic inequalities in the NHS kind of exposed or thoroughly investigated will be an inherently political decision, which I'm a little bit personally pessimistic about, just because I think, the NHS, with a great institution, how it's heralded in our public conscious. I think the realities of whether Filipino workers, for example, and there was at one point even in the pandemic where there were more Filipino nurse deaths in the UK than in the Philippines itself, whether that will be investigated, because that then needs the very uncomfortable conversation about what were white managers doing, ward managers who knew that, Filipino nurses, given their work visa status, are a little bit less reluctant to say no to work, etc. How will that be exposed versus the, other COVID-19 contributing factors? I'm not too sure, and I'm a little bit pessimistic about that, although I would obviously hope that there is space for that to happen. Again, the kind of other overtones of where the National Health Service is right now, it's looking for a new CEO. I'm not quite sure if there's a champion and a leadership from within its own community to kind of have a go at heralding that and making sure that conversation is had. I wish there was, but given some of the other things I said as well about the disparities and the kind of weathering effect of ethnic minority NHS workers, to galvanise and organise and kind of lead that kind of advocacy that Leslie was alluding to, I can only hope that continues, so that association that the questioner asked maintains, and we kind of address systemic inequalities.
Thank you so much, Ade. And this is another question from Sarah, again, Sarah House, which I'd like, each of the panel, and perhaps if we go in the order that the panel spoke, if you can just each sort of think about this for give a few minutes in respect of this. In terms of the inquiry, how will it handle the responsibility of the government versus the responsibility of the scientists? Sarah goes on, there's a risk that the government will blame the scientists for the most things, but there are, she says, some errors, big errors from the scientists, for example, ignoring emergent evidence of asymptomatic transmission, ignoring knowledge on the importance of face masks, etc. So we've got, potentially on an inquiry, there's going to be that tension, that conflict. How do we see that playing out? So if I open that up to the panel, perhaps starting with Stephen and going through to Hannah, Elkan, Ade, and then Leslie.
Yeah, thanks. I mean, it is likely that at any public inquiry, the government will want to deflect responsibility from itself and its decisions, particularly in a situation where it has been saying we must follow the science. But the trouble, what is following the science, and what is it that scientists, in quotes, were saying? There's always going to be a range of different scientific opinions. The function of government is to ensure that it has the most reliable and informed basis upon which it acts. And ultimately, many of the things that the inquiry would need to look at are things that the government took the decisions over, rather than being in some way, misled or duped by some scientist here or there. The inquiry will be about the governmental response, and it is the government that bears the ultimate responsibility, in my view. But there's no doubt many other things that can be said about that. So I'll allow somebody else to say it. Perhaps Ade's next in the order. I don't know what you want to add on there, Ade.
Oh, I was expecting to go fourth, but yeah, I can have a go to say that I agree to a large extent. And again, try not to lose my job. I've seen it with the NHS England's response to the Good Law Project challenge on PPE procurement, where it signalled it had PPE in many places. I think Hannah and many of her community members will also have different views to that. So agree largely with what Stephen says. I think there's going to be a large game of who said, he said, she said, and we'll see it play out.
Thanks, Ade. Elkan and Hannah, if I can turn to the two of you for your thoughts.
Yeah, I'll speak first and Hannah can add if she wants. You always get blame shifting at an inquiry, and sometimes that can be helpful because sometimes the truth emerges from that process. What I think I'm going to find particularly interesting are two things. One, the level of preparedness, given earlier exercises and given, let's say, government funding. I don't want to go into too much details, but disbanding of committees which would have been helpful at the time. That's one issue, which is purely governmental, I think. And the second issue is the decision-making process. And I think that's particularly important because ultimately what we want to do is learn lessons for the next pandemic. There will be another pandemic. There may even be a resurgence of this pandemic. So it's about learning lessons more than it is about blaming people, although inevitably people get blamed. And as Stephen has said, the government will look at it as an exercise of avoiding blame. They're not really interested in learning lessons. They're just trying to dodge the bullets. But from our point of view, and I think from the bereaved families' point of view, they have always said, we want to save lives. We want to avoid future deaths. And that's why, in particular, the impetus was for an inquiry last summer into the timing of lockdown 2. So I guess I'd answer that question by saying the inevitable process of an inquiry is for some people to blame other people. Sometimes from that crucible, a truth emerges. But also, we shouldn't be looking primarily at who's to blame. We should be looking primarily about what has gone wrong and how do we avoid it going wrong next time.
Yeah,
Hannah,
I definitely agree, Elkan. I think it's inevitable that the government will try and blame anyone and everybody except themselves. The line consistently has been, we've been listening to advice from scientists. I think it's important to point out that the government picked which scientists they wanted to listen to. So a good example of that was Professor Niels Ferguson, formerly of SAGE, at the beginning of the pandemic in February and March, advised an earlier lockdown, which could have saved up to half of the fatalities in the first wave. And he was ignored and he actually resigned in favour of people who favoured herd immunity, and then we ended up with such a high death toll. Similarly, in September, when the Prime Minister reportedly was in favour of a firebreak lockdown, similar to what happened in Wales, some ministers, including Rishi Sunak, reportedly brought in 3 pro-herd immunity, anti-lockdown scientists. So when the government say, we listen to scientists, they picked the scientists they wanted to listen to fit their narrative. So I think it's important that if they're shifting the blame onto scientists, it needs to be brought back directly to them.
Thank you, Hannah. Leslie, on this point, and it perhaps brings in some of the issues on Grenfell and the blame game.
Yeah, the question's a good question because it identifies and it predicts exactly what I expect to happen. I mean to say, we've seen it, haven't we, in Grenfell? It's it's not my fault, it's their fault. And I don't think, well, I know COVID is going to be exactly the same. I'm not going to add to this because I agree with what the previous panelists have said, and let's get on to another question.
Thank you. Sarah, I hope that's answered your question. I know that you're particularly concerned also about the scientists and failings there. A couple of sort of more strictly legal questions. One here for the lawyers on the panel. If, as reported at the start of the pandemic, the government was warned that it was coming in December 2019, isn't Article 2 at least arguably engaged in relation to every death, given that the government did nothing meaningful in response to the pandemic until the first lockdown, amounting to a systemic and operational breach of Article 2?
Can I come in? The reality is, I don't think that argument is likely to be successful, and I say that for pragmatic reasons, because the government is likely to say that its response was hardly, and I'm not talking about the response in March of last year or February, March of last year. I'm talking about when clues are being given, as indicated in the question, towards the end of 2019. And what the government is likely to say, isn't it, is that its response was no different than any other European nation, or in fact no different than most of the rest of the world. And if you think about it, I just from a practical point of view cannot see the courts saying that there should be an investigation into all of these deaths. It's not going to happen.
Elkan.
Yeah, can I add to that? I mean, Leslie's completely right, although it's all arguable. And the question was, is it arguable? Yes, it is. Everything's arguable. I think the interesting point that arises from that is, again, and it goes back to this process of decision making, the government was looking to balance in their minds the interests of commerce against lives. And they were prepared to pay a price to a certain extent because they felt to keep commerce going would also ultimately lead, they argue, to saving lives. What I think may have happened is that the way the decisions were made, you end up losing lives and not actually getting the commercial benefits either. And that's something that perhaps could be examined again for the future to see if actually that idea of the balance was a rational idea in the first place.
Stephen, I don't know if you wanted to add anything to what Elkan and Leslie have said. Thank you. Well, another legal question, and it's from our very own Henry Blackson. Hello, Henry. As a number of you are inquest specialists, do you see any basis on which it would be possible for there to be an Hillsborough-style group inquest at which the issues could be considered, or has the framing of the coroner's rule excluded this? Discuss.
I can say, if it helps, we've tried in a number of cases to get inquests off the ground, raising Article 2, and so far we haven't had a single inquest. In Belly's case, recently the coroner has said he's going to hold an inquest. That's the case, I think, of the woman who was spat at in, was it Victoria Station? So that's one, but there have been very, very few inquests because of the Chief Coroner's guidelines, which were amended, but really to no effect. And I suspect there is informal advice to the coroners saying, do not hold inquests into COVID-related deaths if you can possibly avoid it. That doesn't quite answer the question, which is whether it would be appropriate to have a group inquest. I think, yes, if one could be held, I think that would be a satisfactory way of resolving it, because an inquest has the same powers as a statutory inquiry, but it's not going to happen.
Yeah, I would agree with that. It's not going to happen. Henry, it doesn't stop individual COVID cases, and there have been one or two. There was a couple of COVID care home related cases in Manchester, I think, with one of the Manchester coroners, where the Manchester coroner was fairly critical about the stances that the care home took in relation to the deaths of some vulnerable individuals. And in fact, if you have a case as an individual and there's clearly an Article 2 angle to it, it would be a very brave coroner to say that they were not going to hold an inquest. But your question is in relation to, a group Hillsborough type approach. That's not going to happen because of the way that the guidelines, the Chief Coroner's guidelines have been written. Most coroners will say that's not for me, that that's for a public inquiry as and when that comes along. I think that's the response that we'll get. And so I totally agree with what Elkan's saying on that.
I agree with that also, and only wanted to add this, that since it's the comparison is with Hillsborough, which of course was a jury inquest, that one of the things the Coronavirus Act 2020 did was to remove the was to state that COVID-19 is not a notifiable disease for the purpose of requiring a coroner to sit with a jury. So although there may be issues here and there about holding inquests and the relevance of Article 2 and so on, there's not going to be any jury inquests, which again is one of the things that people often are exercised about in this sort of situation.
Thank you. I know that some of the panel need to leave quite soon. A few more questions, and if people are happy to stay around, we can get through those. But perhaps if I put this one out to the whole panel before people have to start going. It's from Hilary Brown, and Hilary says this: is it advisable to work strategically identifying potential partners, such as Wales, within the devolved nations with a view of the fact that the NHS is devolved to Wales? So she's talking about how you know, in terms of campaigning, looking at working with the devolved nations. Again, throw that one for everyone on the panel.
Can I kick off on that, because we've been thinking about that. You can, in theory, have a statutory inquiry for the whole of the UK. There is the power to do that. But in practice, given that so many devolved powers have come into play for handling the pandemic, I think it's more likely that each territory, if that's the right word, each devolved territory will have its own inquiry. The results of that inquiry may feed into an overarching inquiry. I mean, there's no way Nicola Sturgeon, for instance, is going to allow London to hold an inquiry into their handling of the epidemic. It's just not going to happen. So to that extent, there will be separate inquiries, and it is important to try and coordinate those inquiries, yes.
Thank you. I don't know if anybody, Ade, did you want to come in at that point at all?
Yeah, just to speak on the devolved administrations, to say that I think on some of the management of the NHS response, there was coordination. So it would make some sense to have coordinated efforts. So, and there was very close working on sharing information. For example, some of these risk reduction frameworks I alluded to earlier. Also managing PPE as well. There was some kind of sharing when maybe there was surplus in certain stocks in one devolved administration and not in another. Then there was kind of mutual sharing. So some coordination, because there are overlaps, so it would be valuable.
Thank you. I think we can get through the last two questions that I can see in the Q&A. I know Monica has asked a number of questions Stephen has answered. There's one outstanding, and she says this: where an NHS participant in a public inquiry is dissatisfied with the determination of an inquiry chair, where can they have recourse to justice? Leslie was smiling. Leslie, do you want to
yeah, I'll come in. Let me come on that. It's very difficult. The reality is the challenge that you would have if you've got a core participant that's disgruntled with a chair's decision is by way of judicial review. But as you know, the ability to judicially review a chair in a public inquiry is very narrow. There are very narrow grounds. So, you know, the answer is that there is a remedy if you can bring yourself within one of the public law challenges. You know, irrationality, failure to take things into account, you know, things like that. You might have a challenge. But the courts are very reluctant to step into the decisions of chairs in inquiries. That much is known. And even if they do, it might be a bit of a Pyrrhic victory if all they do is just say to the chair, you know, you go away and, you know, relook at this, and the chair does so within the exercise of his or her discretion. So you might end up with the same result.
Thank you, Leslie. I don't know if anybody else wanted to come in. Ade, did you want to come in?
Yeah, thank you, Chair. I'm normally not the voice of doom and pessimism, but I do note the kind of general, I think one of the panelists mentioned the kind of three-pronged approach of having the public on side, and the kind of general racial discourse in this country. You know, it's one of, slightly borrowed from America, of cultural wars. And we saw the response to the Race Commission. It's one I think where significant effort will need to be done to kind of persuade and change public opinion on race in the NHS. And so I think any advice for anyone interested in terms of advocating for a public inquiry, I think there's real communication narrative challenges to getting that as a reasonable thing to do, because the disproportionate impact on Black and ethnic minority staff, you know, is unfortunately for the layperson maybe a little bit of a distant memory. So reminding, also, you know, convincing, persuading people of the need to do this, in my mind, is a really big mountain to climb, but obviously one that I wish is successfully done.
Thank you, Ade. I don't know if Stephen or Elkan wanted to come in any further on that question before I turn to our last question? And it's from Sarah, the person who asked the first question. Going back to that first question about that sort of tension between and blame between governments and scientists, Sarah asks this: maybe the government's role and responsibility with regards to the poor scientific advice is who they requested to advise them. And this is something I know Hannah's sort of touched on, who they requested to advise them and the capacities of Public Health England. I think we've lost Ade. Ade may have gone now, but the remaining members of the panel, if you'd just like to address that if you want to, or if you have any closing remarks now that we've reached our final question. Can I start with Stephen?
Yeah, I don't think I've got anything to add to answer that question other than what's been said already. And my only closing remarks are thanks everyone else for speaking. This has been extremely informative and interesting and worthwhile event. So, and thanks for all the questions that have been asked. So nothing from me. Thank you.
Thank you, Stephen. If I can turn then to Elkan and Hannah.
Yeah, if I can just give a shout out to the Liverpool University students who are watching and hopefully helping. It will be really interesting to see what they come up with. And as far as the judicial reviews are concerned, watch this space, I guess.
I'll just add a brief closing statement. So we've touched already on the fact that the public sort of want to look forward and not look back. And I'm sure that some of the people watching this will agree. But if you are ever in doubt of why we need a public inquiry, I'd suggest that you go to the wall that's opposite the Houses of Parliament in London. We've drawn over 150,000 hearts to commemorate anybody who had COVID-19 on their death certificate. If you've not been bereaved, you can add yourself in your mind to anyone who suffered mental health problems because of the pandemic, anyone who lost a job, anybody who lost a loved one or suffered because they couldn't get an NHS bed. The public inquiry that's needed around COVID-19 isn't just for bereaved people. COVID's touched everybody. So I'd encourage people to join us in campaigning for it, helping out wherever you can. Thank you.
Thank you, Hannah. Leslie.
I think Hannah should have the last word. I think that's really powerful.
I agree. And on that note, we come to the end of our webinar. It's been really fantastic. I hope those who have attended have found it informative and thought-provoking. I certainly have. Thank all the panel members, Ade who's left. Thank Stephen, Elkan and Leslie who have brought their extensive and wide-ranging legal knowledge to some of these knotty questions and really assisted there. And Hannah, on behalf of Garden Court and the rest of the panel, as Leslie said, we're glad we've left the last word with you. Thank you for coming. Thank you for being so articulate and so powerful in what you've had to say, and from your perspective as a family member fighting for justice. And we are all obviously behind you in that ongoing fight with Elkan and others who are all to be taking this forward. So thank you so much. Just leaves me to say thank you to Abigail for, as I said, her sterling work in actually organising and just, being one of the driving forces behind this series of webinars. To David and Amy from marketing for all your technical knowledge and know-how and making things run smoothly. And to all our participants, thank you so much for attending in such large numbers. As I mentioned at the beginning, this is but the first of a series. Our next webinar, COVID webinar, will be on the 26th of May, and that will be looking at the scientific principles underpinning the pandemic. So as I said, that will be 26th of May. Publicity will be out for that and details of the panel. And please do, if you can, join that webinar on the 26th. Stephen's slides are available. Please let Amy and David in marketing know, and we can organise those being circulated to panel to participants. So once again, thank you so much to the panel. for this fantastic start to the webinar series.
Thank you, Alison, for chairing it.
My pleasure.